Start talking about it. Yeah. So we have Richard Goldberg, and he is going to talk to you about, well, the stuff on the screen. Basically, legal and privacy issues in cloud computing. Let's all welcome him. Thank you.
Thanks. I don't have a great accent like the last guy. I am a lawyer. Anybody else a lawyer? Okay. When I talk to lawyers about cloud computing, I usually assume very little knowledge, but a great deal of arrogance. This one I'll assume a little bit of knowledge. I am a lawyer. I'm not your lawyer, except some of you, and you already know who you are. And also, I've been to Shmoocon before. I support the Shmoo-balls. Decide whether your idea is good enough to throw things at a lawyer, and then hurl away. Cloud computing is dangerous. This talk is not about the regular security issues, the attack vectors that you're used to. You can think of these as legal attack vectors. Things you might not have thought of, your lawyers might not have thought of, but it's all in the legal realm. So we're not talking about all the various sorts of attacks you normally have in IT, because those are very similar in cloud. Cloud computing is a lot like flying instruments only. That's why I call the talk that. And the reason is that you're basically stuck with what the provider tells you. And if there's a crash or if there's some other problem, you can kiss your ass goodbye. So there are three questions I intend to answer. One is, what are the risks? The second is, are you protected? And the third is, what can you do? So what is cloud computing? It makes sense to ask for a definition of cloud computing, but for our purposes, it doesn't make sense to answer it because it turns out it doesn't really matter because the things that are sort of cloud and the things that are true cloud are all more or less the same. They have the same sorts of legal problems. This is really old problems that applied to a new medium. There are two things about cloud that make it dangerous. The first is multi-tenancy, having multiple customers in the same place, and the second is third-party possession of your data. And it's the combination of these two, or sometimes just one of them, that creates almost all of our problems. So why is cloud risky? Groucho Marx once said that man does not control his own fate, the women in his life do that for him. And that's sort of the problem. It's a control problem. But it's not just a control problem. It's also a problem of transparency. Now, for technical reasons, cloud proponents will tell you that what you're doing is you're trading in your control and you get back transparency. And that's good insofar as it goes, but it doesn't go that far for legal problems. So last year, if you used Google Docs, you may have received this email. Dear Google Docs user, we've identified and fixed a bug which may have caused you to share some of your documents without your knowledge. That was written by a lawyer. And you know. At that time, Google Docs had about 4.4 million users, and they said that it affected about 0.05% of documents. Now, if you assume that every user had one document, and that's probably not that safe, you end up with 2,200 users, which doesn't seem like a lot if you're Google and have 4.4 million users. But if you're a small or medium-sized company, or if you're a company that has traditionally had problems keeping track of its documents, that's a lot of documents. On October 4th of 2009, there was a Sidekick problem. Now, Sidekick was run by a company called Danger. Microsoft had purchased Danger, which is weird because Microsoft usually sells Danger. But on October 4th, about 1 million customers lost their data. And while Microsoft and Danger and everybody went searching for the backups, it took 2 weeks for it to be restored. Now, part of that was the problem was that these devices would lose their data when they were reset. I don't know who thought that was a good idea. But it meant that the data, when it was restored, was 2 weeks old. And in the meantime, if you were using this for your business, you were sort of screwed. On October 19th of last year, there was a problem with Google Voice. Voicemail transcripts began showing up in Google search results. Now, Google apparently knew about this and went about trying to fix it, even though they said it wasn't a problem, but didn't tell anybody. There's an old saying, he who knows does not speak. They sort of meant Google, and maybe also Toyota if you've been reading the news. So maybe October is just a bad month. And maybe Google Voice isn't true cloud, or T-Mobile Sidekick wasn't true cloud. But the question is, when you're looking at this before the failure, how do you know? With a lack of transparency and with no control, you can't. Which means that cloud computing right now is a lot like bungee jumping, where you don't know the height of the bridge, or the length of the rope, or if the rope is made of rope, or if it's attached to anything but your ankles, and you don't know any of these things until after you jump, because you can't test it. So there are 4 things I want to talk about. The first are inherent dangers. These are the sort of direct dangers that are inherent in this sort of thing. They're things you might have been warned about, but you still may not see them coming. The second are service agreements. These are the cloud service provider agreements. What some of them say, they're all very similar. The third are collateral dangers. These are the things that you really probably didn't see coming. They're legal issues that come from the side, and you might never have known that they were there. And the fourth are solutions, if there are any. So inherent dangers. As I said, these are the things that you may be warned about, but even if you're warned about them, you still may end up in trouble. The first is federal data protection laws. There are some. They tend to apply to industries specifically. For instance, there's HIPAA, the Health Insurance Portability Accountability Act. This requires a few things. First, it requires what are called business associates agreements. These are agreements with your data providers, service providers that basically apply HIPAA to them. Google Docs will not agree to this. The second is that you have to protect against reasonably anticipated threats or hazards. I don't know what's reasonably anticipated anymore, everything. And the third is if you don't have your data encrypted, the data breach reporting requirements are very onerous. Bobby Rush sponsored a bill in the House this year that passed in December called the Data Accountability and Trust Act. It had protections for identity theft that mirrored the banking industry's protections. It also required notification to consumers and the FTC unless there was a finding of no risk of harm. Now, unless they know what your data is, I don't know how they know. What's important to you, how they know what's no risk. Importantly, it preempts existing state law. It was only passed in the House, so it hasn't obviously gone into law yet because it has to be passed by the Senate and signed by the President, but it is a possibility. Now, Senator Leahy also introduced something called the Personal Data Privacy and Security Act. These things may end up getting melded. The idea was notice, again, and a few methods to prevent data breaches. Now, he's introduced this thing 3 times. I don't know if it'll ever pass. But it's not just the feds. The key data laws are in the states, and there are a lot of them. 45 states and DC have data breach laws. They're all different. Some are less strict. Utah requires a person who becomes aware of a breach to determine the likelihood that it has been or will be misused. I don't know how they know that, especially if it's my data. Some states are stronger. Massachusetts has a law that goes into effect very soon, requires encryption of transmitted records, requires encryption of stored records on portable devices. It, by law, will require operating system patches. The key to these is that they all tend to do 3 things. One is they require some level of security or other. They require notification on breach, and there's an added requirement for certain types of data, like health information, that they notify you. And they may have to notify the FTC or other entities. There are international data protection laws. The European Union has very strict laws, and in particular, the UK Data Protection Act does not allow data to be transferred outside of the country unless the country to which it's being sent has an adequate level of protection. This comes into effect in different ways. If you want to transfer email out of the UK, it requires employee consent, or the consent if it's not an employee. That consent has to be free, informed, and revocable, which means that you cannot tell an employee that unless you consent, you're fired. That's not enough. That's not free. I had this happen with a client who was in the US. The company stored email in the UK, and the US government showed up to the US version and the US company and said, hey, we'd like your email. Here's a subpoena. And they had to get her consent to get it back in the country.